Well, hello everyone. How's everybody doing? Thank you so much for attending our webinar. Uh, my name is Robert Levin. Let me just go ahead and get started. Uh, my friend and associate sitting right next to me, Jeff Sykes, he's going to help me with some questions. I might answer some quick ones. He's going to help me to make sure I don't miss any, and any lengthy ones he'll help us read. I can't thank you enough for being here. The name of the company is Safeguard Estate. The owners of the company are Tom Perzak and John Owen. They've both got well over 25 years of experience in this industry. And Julie Jewett is the office manager. She's lived here in Arizona her whole life. And I just want to show you, we're right over here off the corner of Hayden and McDowell. That's our building. The only one in the buildings are us and the attorney. The attorney's name is Mark Hall. I'm going to get to that in just a second here. I want to tell you about this disclaimer. I'm not an attorney. I'm not allowed to give legal advice or even an opinion on legalities, but I can share my experience, and I've done this a couple of decades. And so I can tell you whatever the attorneys told me, and I can share some of the stuff I've learned. Most of my experience was in California. My first 18 years, I dealt a lot with judges and attorneys and all the different courthouses, so I could speak to my experience. The attorney's name is Mark Hall. Mark's been an attorney in Arizona over 20 years. He's an attorney quite a bit longer than that. He's a great attorney. He's the only one we use, and this is where his main interest, I should say, is estate planning. That's what he does. Estate planning, asset management, and real estate. That's his wheelhouse. And so before we get started, I want to tell you what I want to do today. I moved here a little over 5 years ago with my wife and my daughters, Allison and Shayna. I just want to tell you why it's really important to protect yourself. Why we at Safeguard believe it's important to protect yourself. And if you think it's important, after I'm done explaining what I think is important, then of course, you only have two real options to do it. That's either a will or a living trust. So I'm going to explain the differences between wills and trusts as well. And I'll try and keep it direct and brief as I can, but I'm asking you, please reach out and ask me questions. We're really eager to answer questions because I really don't have enough time to tell you all of the benefits of protecting yourself. Like, for instance, with a living trust, if you're interested, I would need, honestly, 3 days to be able to tell you everything that happens with a trust. But I'm going to summarize it, and any questions you have, please ask, because it benefits everybody to hear the question and the answer. So I just want to say thank you for being here. I'm going to go ahead and get started. There's three groups of people that come to these webinars, of course. The first one, well, that's with nothing in place at all. No will and no trust. That's self-explanatory. The second one, of course, you might have a will in place already, so I'm glad you're here. And the third one, well, you would have a trust. That's really it. And in order to tell you what's really going on, I have to tell you about the problems first. So I've got to talk about something I really don't want to talk about, but it's important you understand it. So I'm going to address something called probate. Probate's very simple. It's where you haven't protected yourself, or you haven't protected yourself in a way that the court, I guess, would deem properly done. And now a Superior Court judge would step up and they get to decide everything that's going to happen regarding everything you've worked for your whole life. So they decide who gets it, when and how they get it, if they get it. It falls into their lap. And so that's just one of the things. There's also a living benefits, which is important to protect yourself while you're alive. So we're going to go over that too. With a properly done estate plan, there's many more living benefits than there are death provisions. So it's really important. So getting started here, probate. As you can see right there on the screen, probate is the judicial process where a will is proved in a court of law and accepted as a valid public document. That is the last true testament of the deceased. Okay, well, if you notice that first line there, it's talking about a will. You know, 20, 25 years ago, our parents, our grandparents, they passed away, and wills worked great. If somebody argued, you know, they had the authority to enforce it, but not anymore. Nowadays, wills get approved in a probate court. In Arizona, it is not mandatory probate if you have a will, but still, it only takes one hiccup. If somebody argues or a creditor shows up or there's a problem on paperwork, they People these days, they hire in the banks and savings and loans. They read obituaries. They're hired 40 hours a week, and that's all they do. If they see your name, they'll freeze the money and they'll notify the probate court. So the real issue regarding your assets is to avoid probate. If probate starts, you have to go through with it. If you can avoid it, that's different. And really, everything I'm about to tell you, it comes down to this. If you're protected and you're protected properly, then everything we're about to talk about cannot happen. And if you're not protected, then you're vulnerable. That's the best I have. I don't have a crystal ball. So it's one of those things. We like to prepare for the worst and then, of course, hope for the best, but we're prepared. So let's go ahead and talk a little bit about probate. I just manufactured an estate here. I gave it $500,000, so I have something to talk to you about. The way the judge does it is he'll send an assessor to your home. It might be, it's going to be his own assessor, not a county assessor. And it's going to be in his own good time. And they're going to go there and they're going to get a value on your home, and that's the value. And depending on how probate lasts, they don't go ahead and get a new market value on your home. And there's different reasons why probate can go longer. The average time of probate here is between 1 and 3 years. So you can see already it's not fun. Then the work is going to start. He's going to send some people into the home. It might be 2 or 3 people. They're going to catalog everything. They're going to get a value. So they'll count t-shirts and silverware and everything else. And then they'll find your money everywhere and add it all up, do a forensic accounting of everything. And that's when the judge now has something to work with. So from that point, he's going to have to find out if you have any debts, or do you owe any taxes, or do you have any children? And of course, if you have children, he has to figure out if you wanted to give them anything or not. It's now in his court instead of yours. So in this case, I have a $500,000 estate, and we start off with court costs. The average on court costs here in Arizona is between 6 and 22% of your estate. Okay, I tried to stay conservative. I went with 10%. The truth is it could be less. It does tend to be more. But even at 10%, that's $50,000, as you can see on the screen. That's a lot of money. And we're not even talking about just earning the money. You had to save it. We all know how hard that is. It doesn't stop there. Now the attorney usually makes at least as much as the court. So in this case, in this scenario, that's 20% of your estate. That's $100,000. I can't imagine any of you don't think that's a lot of darn money. And it could be less, it really can, but it tends to be more, and it goes over a period of time. See, people, as they say, come out of the woodwork. Anybody that makes a claim, the judge handles everything 1 foot in front of the other. It's one at a time, and everything makes it go on longer. Here in Maricopa County, for instance, they have what's called a transaction fee. So everything that you do, it might already have a fee attached to it. And you know how many hundred transactions you might have in a couple of years in the court. But each and every transaction has a $30 fee attached to it because it's a transaction on top of whatever fee it comes with. So you can see how the cost could go up. This page right here is right off the Maricopa County website, Superior Court website. At any given time, there are more than 20,000 active or pending probate cases in Maricopa County. And they're adding more than 500 every month. And as you can see, there's only 2 probate court commissioners. So you can understand how it could go on. I imagine if they had 4 commissioners, it might be faster, but they might make less money. It's just speculation. The problem we really have is everything gets approved in the probate court. It's an issue because each and every county, including the state, they make millions of dollars every year in probate. They're not shy, they're happy to do it. If your estate is in probate, then everything in your life is now public information. It's in the courthouse. They're going to know if you've ever been in jail, if you've been in the hospital, if you ever had any mental issues, how much money you have, what do you own, everything. And so that's an issue. They're going to have your children's information, their contact information, addresses and phone numbers. So you can see where it would be a problem. Anybody can go in there. They can look at it. It doesn't cost them a single penny. If they want, copies are pennies a page. So let's say, for instance, someone went in there and say, I want to see a probate case. Well, who do you want to see? Well, how about my neighbor? So you can understand where this could go. They can go in and say they want to see the last 20. They could do a lot of things. It's unfortunate, but you see where we're vulnerable. If your estate's in probate, the judge is going to pick someone and appoint him as an executor. If you had a will, he might use who you chose. He might not. There's no way for me to tell. It's his courtroom. He's going to assign someone. And then he's going to tell him to go run an ad similar to this page right here, or exactly like this. It's up to the judge. But he's going to tell the whole world that you've passed away. And if they want to make a claim, come on and do it. They're going to have to run an ad in 3 different papers. And all of those ads will run for 6 months. And who thinks nobody's going to show up? If nobody shows up, count your blessings. But how do you know? So I don't see any questions as of yet. I hope I'm doing a good job. Please let me know by asking some questions. We've just talked about probate. I'm going to give you a quick example on how that works. Here I have a husband and wife, and I want to explain that ownership and title are the same thing. Most of you understand that, but you might not be aware of how they use it. So in this case, one person has to pass away first. So I'm sorry, guys, all the guys out there, I never take out the ladies first. So if one spouse passes away, she's still here. This is Arizona. It's a community property state, and most of the time she's fine. There are times where issues can happen. Sometimes blended families cause something, sometimes not. Sometimes paperwork problems. Any number of things can happen, but we're going to say she's fine because most of the time she is. There's nothing interfering other than there's work to do. Whenever someone passes away, it's work. Sometimes it's months, sometimes it's longer, but in this case, it is just work. So now what happens when she passes away? Here's the big question. Who owns everything now? Well, if you remember, title and ownership are the same thing. So for the moment, nobody owns it. See, we just took title to the grave with us. Now, with or without a will, we're going to go to the bank or anywhere we have our assets, and we're going to tell them, these are the people I care about, my children or whoever we love. Please give them my money or whatever it is when I'm not here. Well, you ask them to manage your assets for you when you're not here. So, of course, that's where the beneficiaries are. If you have a will, the problem is it names your beneficiaries. So if you want a literal explanation, the names are heirs in a will. They're beneficiaries at the bank. So the will doesn't have the ability to enforce anything. It's a letter of intent. It tells, I really want this to happen. But the problem is when you pass away, that's on one day, and many, many days later, maybe months later, that's when your beneficiaries would get something. So in the meantime, we just took title to the grave with us. So that time in between, that's a lapse in ownership. That's when anything can happen, including probate. That's how it works. I've asked 3 judges the same question. They're all probate judges. And I asked them, Your Honor, what is the purpose of probate? And they had the exact answer. To establish clear title to an asset. So they get to decide who owns it. That's what the issue is. So effectively, what we want to do is avoid losing ownership. That's where we really are guaranteed that we won't have probate, because if we never have a question in ownership, then the judge doesn't have an opportunity to get involved. Okay, so let's talk about wills. All right, so wills in Arizona, approximately 70% of all the wills in Arizona end up in probate. It's a problem. The reason it's so many is because it only takes a hiccup. When people around us pass away that we really care about, when we're really in a lot of pain, who do we take it out on? Right? We take it out on those that we care about, those that will listen. And sometimes it just gets carried away, but it doesn't matter. If there's an argument or someone in the bank sees your obituary or any hiccup at all, the neighbor comes over and says, that beautiful car your husband's waxed for 30 years, he said I could have it. All of these things can start a probate. A stranger, anybody can come make a claim. And again, we've talked about public records. It's all in there. You understand it's all there for anybody to look at, even family members. So the question becomes this: family conflicts, blended families. Do you trust everyone the same? Cousins, nephews, in-laws? They have access to the information about your whole estate. So would you trust them with your whole estate? That's a question. Okay. Blended families, the Brady Bunch, that's the perfect example. Family complex. When you have a blended family, and let's say the father passes away and mom's still here, the kids showing up, it's usually not malicious. It's just pain. And they, they show up, get out of dad's house, or we want dad's stuff. They just want a hug. The problem is it's hard to realize that. It's never malicious almost. It's just pain. And do you trust everyone? Gladys Kravitz is the perfect example. Neighbors, family members. Remember, they have access to everything about your estate, so they can come in and make any claim they want. They can go to probate and look at it. It costs them nothing. That's summarizing a will pretty quickly. I'm going to go right into trust because I don't see any questions yet. Okay, so trust. There is 4 parts to a trust. The way we set up a trust, it's similar to a business, and this is why it's so effective. If you own a company or a business, then everything that company owns is yours. It's very simple. So how it goes is we have an owner and a manager, a trustor and a trustee. You're both of them. So if you're married, you're co-trustors and co-trustees. As a matter of fact, if one of you were to pass away, nothing changes. All that work that you normally would have to do is already done, because there's something called funding. Funding the trust is just fancy words for giving out your assets to the trust. So this is where Safeguard comes in. What we've done is we've separated the attorney. So Mark Hall, he's a $300 an hour attorney, and now he's going to give you a flat fee. And so you get one fee with us, and that's it. There's no hidden fees, no monthly fees or annual fees. There's one cost. And now Mark will set up everything, and he's your attorney of record. You have an attorney-client relationship with Mark, but he's very easy to talk to, just like this. He'll answer questions ongoing. Once you're a customer, you can always ask questions. He's not charging to answer questions. So we are the customer service side of it, which allows us to provide you with ongoing services without the ongoing fees. I imagine that's good news. So the funding, that's when we give everything to the trust. So we give the house to the trust, the bank accounts, everything. The trust is now going to own it all. But you're going to own the trust. You're still going to buy and sell everything normally. Nothing's going to change there. For you, it's semantics. But for someone that might want to interfere with you while you're alive, or trying to interfere with your estate after you've passed away, well, it becomes a roadblock. So that's the difference. So in this case, if one of you has passed away, the other one's here, all that work you normally have to do, you don't have to do it. It's already done. The trust owns it, and it continues to own it, but you own the trust. So the surviving spouse can now actually mourn because they're protected. If you both passed away, or if it was just you and you've passed away, you need someone to step up and distribute your assets according to your wishes. And there's many ways you can do that, but we don't want them to be an owner, just a manager. That's why there's 2 names, because only an owner can change it. So while you're alive, you can change anything you want. Who gets what, how they get it, when they get it, who's in charge, anything you like. But when you pass away, you have a successor trustee. It's just a manager. They have to step up and distribute your assets according to your wishes. Now, you can have one person or several people working together, or you can have, this one here, and heaven forbid they're not available, then it's this one and then this one. But what we want to do is we want to have contingencies built in so that there's no concerns. Because heaven forbid, you have a child or someone you really care about in that position and they were to pass away, 10 years later, you're not trying to figure out how to fix paperwork. So we already have a contingency built in. Now you can change it anytime you like, but we have this prepared for you. Your successor trustees are going to give everything to your beneficiaries, whoever they are, whatever you want. They could be the same people if you like. Your successor trustees and your beneficiaries could be the same. They don't have to be. Again, it's all up to you. I'm going to stop here for a moment and give you some examples on the differences between a will and a trust so you really understand it. So I've got 2 girls, Allison and Shayna. I'll give myself a 3rd child. So I've got Allie and Shayna. I'm going to give myself a child. His name is Johnny. He's my oldest boy. Now I have 3 kids, so I'm going to raise the value of my estate to $3 million because I can. So I have 3 kids and $3 million. So let's say I passed away, right? I told Johnny when he's 20, please be a good kid and take $1 million and give $1 million to each one of your sisters. He's like, okay, Dad, he's great with this. He knows he's going to be a very wealthy man. But when I pass away, he's 60. Now he knows, he knows his earning potential. He knows the value of a dollar, and I'm not here to hold him accountable. So what if he goes over and he grabs his $3 million and he decides to keep it? Okay. Well, if I have a will, he didn't break any laws. He did nothing illegal. He violated my wishes. It's unethical and all that. But he didn't do it maliciously, and most likely it's out of fear. He's 60 years old. He might have concerns. The problem is I asked the bank to manage my assets, and they did. They gave it to him just like I asked. And so now what? Now it's a civil case. There's nothing in the estate, so there's no probate. He's got all the money, so generally speaking, he would end up with 80 or 90% of the money and just waste the girl's money if they tried to fight for it. That's how it usually works. But on the other hand, if I had a trust, remember the trust, we put the trust name on the account for you. We put the trust name on your house. The trust owns everything the day before you passed away, and it continues to own it the day after. We have no lapse in ownership. We haven't asked anyone else to manage our assets. Nobody gets to interfere. We just cut out bankers and attorneys and judges. And as we go, you'll notice we've cut out doctors and nurses and social workers as well. But for right now, because the trust owned it and didn't say he can have it, he just stole the money. Does that make sense? He took it. So now he has to give it back, but not just their share. He loses his share as well. So the girls are now, they get 1.5 million, he gets nothing. And he has to figure out how to afford his attorneys he has to pay because he's going to have some legal issues. So you can see how that works. Another thing, let's say he was 45 years old and he had an issue, in a car accident maybe. And now he was in pain. Maybe he's got problems with drugs and alcohol now. Well, if I have a will and I give him all that money, that's my only choice, is to give it to him or not. If he gets it, my personal opinion, that's very dangerous. He might end up just killing himself in the next couple of months with all this money, and gives him much more access to that stuff. But if I have a trust, I can actually dole it out any way I want. So when you think about it, I can say, you know what, I'm just going to pay your rent every month, or I'm going to give you $1,000 a month or a day or anything I like. I can give him $5 a week every week for the rest of his life. And if I don't change that while I'm alive, then that's what he gets. And if he wants to argue, he loses his share. He's not even allowed to argue. You see, another great benefit of Safeguard is we're going to settle the estate with you. Whoever you choose as your successor or trustee, they're just going to call Safeguard, and we're going to hold their hand and walk them right through it. This is no charge. It's included. Our average time of settling an estate here in Arizona, if there's only one property, is 48 days. We're incredibly fast. But, we're talking about losing parents. It's probably going to be one of the most devastating events that ever happens in their lives. We're just trying to ease that burden. We do get rewarded. I'd love to tell you we're angels, and we believe we do a great job. All of our customers are considered part of the Safeguard family. But we don't charge at all for this, and we're worried about tax deadlines and everything else, so we're very fast. And usually 3 or 4 months later, the family members come back and tell us, thank you. And they now have all the assets, and they ask us to set it up for them now. So we get rewarded. We have generations of family members getting trusts and stuff with us. And I'll give you one more example. Let's say, for instance, let's say Johnny was a good kid, but trouble follows him. I know he can sit in the back seat of a car in a parking lot and someone's going to run into it. So I'll tell him, Johnny, do me a favor. This is, our trust, but we're going to call it the Johnny Trust for the next 40 or 50 years after we pass away. So let's say I pass away and a year later, somebody sues Johnny. Well, he's keeping the money in the trusts. He's only pulling it out if he needs it. So they sue him. They can't touch that money. He could sit down and tell him he has another $900,000 in this account, and they can't do a thing about it because it's in my trust. He can take it out when he wants, but they can't make him do it. See, it's protected, and it's still his. You can do many, many things with a trust, anything you like. It's wonderful. I'm going to give you some quick examples now of people that went through trust, just to make sure you understand it doesn't matter who you are, doesn't matter how much money you have. You're either protected or you're not. And if you're not, you're vulnerable. I don't know a better answer. So let's see. Walt Disney went through probate. Marilyn Monroe, Elvis Presley. John Wayne did 15 years of probate. Howard Hughes was 34 years of probate. He had 17 attorneys, but they were corporate attorneys. So, you know, you want to get the right attorney. JP Morgan. JP Morgan, they said he was worth 87 billion with a B, $87 billion when he passed away. And he had billionaires waiting for the money. His heirs were all billionaires and they couldn't do anything to stop it. When probate was done, it cost 70% of his estate. So I hope that registers. If you remember Fred Mertz from I Love Lucy, William Frawley, he had less than $100,000 in his estate when he's passed away, and probate cost 49% of his estate. So it just doesn't matter how much money you have. And my last example I'm going to give you is just because it's a wake-up call. Jacqueline Kennedy Onassis, right out of the heart of the family, she went through probate. Her estate went through probate, and the Kennedys couldn't stop it. So what chance do we have? That's really it. It's if you're protected, it can't happen. And if you're not, well, you're vulnerable. So I'm going to show you an example now of what happens when you have a trust in place. Same example we had before. This time we have a trust. So I have this married couple, and they own everything just like before, but now they're going to get a trust. So Safeguard, remember we're doing the funding. It's just helping you. We're going to help you take everything out of your name and put it in the trust name. So now we have this. And we're going to do that for the rest of your life, by the way. There's no fees. You get a new home or you move money around, please call us. We'll help you protect it. Okay, so now what happens? If Mr. Smith passes away, Jane's still here, and she's not worried about anything. She has no work to do. She can actually mourn. Then when Jane passes away, as you see, the trust is still here. The trust is allowed to survive you for up to 500 years. So if you want to give away charity or anything you like, it's very easy to do. Your trust will do it. So now what happens? Your successor trustee steps up to distribute your assets according to your wishes, whatever that is. Another benefit is our trusts are designed around special needs. So it's a true benefit if you have any children like that. I would say it's almost necessary to have a trust if you want to give them anything. But in this case, your successor trustee is going to call Safeguard. And again, we're going to hold their hand and walk them right through it. Okay, so I don't see any questions yet. Please ask some questions and thank you for being here. Okay, so the reason that works like that is there's no lapse in ownership. Again, the trust owns it the day before you passed away, and it continues to own it the day after. So let's go ahead and talk about the living benefits, okay? So living benefits. When does a will take effect? Okay, well, a will doesn't take effect until you pass away. So until then, it's just a piece of paper. But a trust, when does a trust take effect? Well, a trust takes effect the moment you sign it. You sign it and we witness and notarize it, and it's in full force right then and there. So you can see where it could take effect and have some benefit. So what if something like this happens? What if you have some kind of a medical issue or a car accident or anything at all, and stroke, and you can't make a decision for yourself or you can't communicate? Well, who's going to make those decisions for you? What if you're incapacitated? These are very big questions. And the problem is you need to be prepared ahead of time. That's what we're talking about. I'm going to give you an example here. Terri Schiavo. Some of you might remember her. She was 27 years old and she lived in Florida, and she had a massive heart attack. The problem was that the first responders, it took them almost 7 minutes to get there and resuscitate her. So even though she was breathing, she was brain dead before they ever left the house. They rushed to the hospital, and the moment they walked in the hospital, the state of Florida was appointed as the conservator. So they're now in charge of the money, Mr. and Mrs. Schiavo's money, and they're paying themselves $1,500 a month from their money to be in charge of it. And the other problem was she was in cardio intensive care unit, CICU. That was $5,000 or $6,000 a day. It's pretty much triple that now. And the issue the doctor had was if he had said she wasn't here, he would have cost the hospital over $100,000 a month. And the hospital is beholden to stockholders and a board of directors. He cares about the patient, but she's not here. So that was the dilemma. I've asked other doctors and they said he's trying to protect his career. So that's what it was. So in the meantime, the only option Mr. Shivo had was to petition the court for legal guardianship to stop that outlay of cash, to stop his wife from disintegrating on this feeding tube. Okay, so he petitioned the court and he won. It took 8 years. 8 years. Okay, so he finally gets an opportunity to take his wife off this feeding tube, and he does. And 3 days later, they put it back. Her mom took him back to court for 7 more years. Okay, 15 years. Because he didn't have the right paperwork? Because he didn't have the right documentation? Okay, it's extremely unfortunate. Nobody tells you that it's just paperwork. If you have the right paperwork, they cannot do this to you. Okay, if he had the right paperwork in place, then he would have automatically been her conservator. And if he would have been in an accident with her, and then his successor trustee or he would have had it set up. There would be already someone in that seat. For me, it's my oldest daughter, and if not her, then my other daughter. See, the seat's not open. If it's not open, they can't sit in it. So should it have been his decision? I think so. Was it contested? Yes, it was contested by her mom. Okay, I'm going to give you one more example for incapacity, another one. I'll use myself. Let's say I've passed away and my wife is still here and she's 80 years old. And something happens. It doesn't matter what, stroke, Alzheimer's, bumps her head, trips and falls, car accident, anything at all. The issue becomes whether or not they declare her incapacitated. So if a nurse or a doctor or even a social worker says for some reason she cannot handle her own affairs, that's the issue. So let's talk about what happens if I don't have the right paperwork in place. Okay, and I've heard the stories. People ask me, what if they're lying? It doesn't matter. We're going to assume they're telling the truth because either way, she's in the same predicament. So they're going to have what's called a local magistrate step up and have a conservatorship hearing. Now, a local magistrate is a superior court judge. In this case, it's here in Maricopa County. And he's going to have a conservatorship hearing, and I've asked those judges the questions, Your Honor, why don't you appoint the children as conservators? And they tell me because the children have a conflict of interest. They're spending their inheritance. So the judge tends to appoint an attorney. Okay, so the attorney has options. He can keep my wife in her home where she's comfortable and familiar. It might be the only thing she recognizes. He's going to gather up all the money. That's the first thing he's going to do. So if you have 401ks or IRAs or bank accounts, whatever he's going to do, he's going to collect it all and he's going to move it into what's called a guaranteed account. So if you had beneficiaries or anything on those accounts, that's over. He now moves it into an account at Merrill Lynch or something, wherever he's used to working with someone. And a guaranteed account simply means there's no fees or stocks attached to it. And the money only goes down if he has to pay a bill or something. And so, like I said, he can keep her in her home. He can hire hospice care and he can monitor that for 24 hours a day. He can monitor my children's visits, he can monitor everything. And he can reach into this account and pay bills, or he can just put her in a home and monitor nothing at all and just go ahead and pay the bills. You all know what he's going to do. In fact, if he wants to, he'll sell her home and put it in the account, and then the estate is over. He's just destroyed the estate. Okay, my option is my daughter. I have the right documents in place. My daughter, Shana, will step up, and she will keep her mom in her home because she loves her mom. She'd never put her in a home. She will hold hospice feet to the fire. She'll never destroy the estate. If my wife was to get better and Shana wasn't involved, they wouldn't even give it back to her. It's a court order. She would have to go argue in open court at 80 years old and try and convince a judge she can handle her own affairs. And half the time, the attorney that would be about to lose his payday would be arguing against her. Which one do you want? That's what it comes down to. Which one do you want? There's some questions? Let's see. Okay. Does a deed of trust exempt a home from probate? No. A deed of trust is just you're the owner, and once you've passed away, now there's no owner. And I hope I've been explaining how it works if they sell the home and so on. What happens with a trust is we put it on title so the owner never passes away, and the trust gives it to whoever you like. Can you help me with this, Jeff? What does it say?
Isn't
thank
there a minimum threshold below which an estate is not subject to probate?
Well, yes and no. Okay, so here in Arizona, they asked if there's a threshold. So it's not supposed to start unless you have $75,000 or more. And most of us, if you have a house, you've got that. But here's the issue with that. You remember there's people in the banks and savings and loans and credit unions that read obituaries. Or somebody can show up in the woodwork and anybody makes a claim, it could start a probate. So one of my customers, his mom, she was on Social Security and she passed away. She had $384 in the bank, but someone at the bank read her obituary, and so they froze the money and notified the probate court. And he had to show up. So he got a hearing date. It was 8 months later. He showed up without an attorney, and the judge asked him, I see there's no attorney here. What are we talking about? And he said, Your Honor, she just had the money in the bank and a few $100s with furniture. And he said, okay, you can have the furniture. Next. So it's not supposed to start until there's $75,000 or more, but any hiccup can start it. So that's a very good question. Thank you.
Okay, here's another one. I have a question regarding wills and real estate. If your property is titled as a joint tenant with right to survivorship, can that property still go to probate?
Well, yes, it can. So let's say, for instance, only one of you passes away. Usually there shouldn't be a problem. In that case, if there was a problem with paperwork, which we see in the office relatively frequently because a lot of you have bought your home 10, 20 years ago and you've never checked those deeds. So we check them all the time. But other than a problem with paperwork, usually not there. But once you've both passed away, yes, the home's going through probate. Exactly what happens. Thank you. Great questions.
Here's another good question. Regarding a grandson who lives with us who receives SSI and Medicaid, if we include him in a trust, will he lose his SSI?
That's a great question. No, in fact, here's the problem. So it takes anywhere usually from 2 to 5 years to go ahead and get him qualified and have them give him SSI. And now they're going to pay his medical bills for the rest of his life, and they're going to give him money every month for the rest of his life. So we don't want to lose that. So Mark really wraps these trusts around SSI. What happens is this. If you give him a bunch of money, let's say you gave him $100,000 and put it in his hands, it's no problem. But the moment some of that hits his Social Security number, like putting it in a bank account or something, that's when they take his SSI away. So when you have it in a trust, it can be managed within the trust and used for his benefit in any way you see fit. You can give him the house, he can have everything done for him, and he won't lose his SSI. That's one of the most important reasons for having a trust. Thank you. Great questions.
Is a revocable living trust the same as a living trust?
Yes. They call it by many names, a revocable living trust, a family living trust, a trust. It's all the same thing. Revocable means you can change it or you can eliminate it if you want it, but while you're the owner, you're alive, it's revocable. And once you've passed away, that's when it becomes irrevocable, meaning nobody can change it. Your wishes are now in stone, and whoever you've chosen as a successor will distribute your assets according to your wishes. They have no other option. And that's as in any way you see fit. You can give them liberties or direct them entirely. Great questions. Thank you. Any more?
Nope. Let's carry
Oh,
on.
fantastic. Thank you so much. Okay, so you see that page that's up there now? That's regarding the disability I just mentioned. For instance, if they put my wife in a home and so forth. The local magistrate that steps up, that's a judge, okay, a commissioner. So judges and commissioners assigned to the probate and mental health department. They oversee currently in just Maricopa County more than 9,000 people that are in that situation I just described. They're controlling all their assets. It's over $500 million. And any orders for active treatment, they're the ones doing it, not your family members, some attorney that's working on their behalf or this judge. So you see why it's so important. It's either, the judge and the attorneys in the state of Arizona, or it's you and your family. I really believe it's which one do you want? The problem we have is, statistically speaking, over half of us are going to be disabled sometime in our lifetime. That's the statistics. And so we have to face the facts. So being prepared is really the best we could do. As far as living benefits go, you have healthcare power of attorney, it's already established. Financial power of attorney is already established. Conservatorship is already established. Physicians, authorizations, living will, every bit of it is already established. So what it is it begs that question, doesn't it make sense to protect yourself? Do we have more questions?
Is there a capital gain when our children get our home and assets?
That's one of the best questions. Thank you so much. Like I said, I don't have enough time to tell you everything. Okay, so I'll compare it to something. Sometimes people put their kids' names on their home and their bank accounts. The problem with that is there's twofold. The first one is it's a liability. They're out and about a lot more than we are. And if they get in a car accident or go to work and somebody sues them, you can lose everything their name is on. And we just don't have 50 years to get it back. Now, the other question answers the one you're saying. If you put their name on the home, for instance, you expose them to capital gains taxes. So if the home is worth $350,000 more than it was when you bought it, and now the kids owe a little over $86,000 to the government, and they never forget. But to answer your question, if we give it to them through the trust, that's a wonderful thing. So now you give it to them, it doesn't even have to be your kids. It could be your neighbor or your best friend, whoever you give it to. They get the whole thing. If it's worth $5 million more than it was when you bought it, they get every penny. They legally avoid capital gains taxes. In fact, so if you're married and you pass away, your spouse gets a stepped up evaluation. Well, now what you're effectively doing is whoever you're giving it to, they get a stepped up evaluation at full value, and they are not responsible for any of the capital gains. And they also get the next year. So if your house is worth $1 million and they keep it for 2 more years and it goes up another $1 million each year, and now it's worth $3 million. The first $1 million they put in their pocket, the second $1 million they put in their pocket, and they probably pay a couple $100,000 in taxes on the other $1 million. So they end up with about $2.8 million. What I'm trying to share with you is it's wonderful. You avoid capital gains entirely, and if they keep the house for another year and it benefits them in capital gains, they get that too. Great questions. I can't thank you enough. So Susie Ormond, okay, she's talking about our trust. What you just asked about a revocable living trust. It allows your heirs to avoid probate entirely. Whereas a will, if we give you a will, we can minimize the risk greatly, but we cannot eliminate it. You're still vulnerable. But with a trust, we've actually eliminated the probability of probate. It keeps you in complete control of your finances, not only while you're alive, as you already know. You can control it from the grave if you wish. You can use it to send kids to school or bribe them to go to school or anything you like. And ultimately, you can change anything you want. Who gets what, when and how they get it, who's in charge, all of it. It's all up to you. It's your estate. The difference between most attorneys and Mark, the way they do it is, if any of you have these documents, and you already know you went to the attorney, hopefully, but he had to create value. It could be the best attorney in the world, but he works hourly and he has to create value. So he talks about everything you own. And then when you're done and you decide to move forward, he pushes it all aside. And he creates the paperwork and he gives you a letter that says, go protect everything we talk about. Well, he's protecting himself, because if you don't protect all of your assets and your children come back and tell him he didn't do his job, he says, yes, I did. I told them to protect it. That's different. And they're also using a software program, so it's someone else's program, because they do a lot of things and they usually charge a lot of money because they don't do this all the time. So it's a fill in the blanks kind of a thing. And there might be a bunch of things you weren't allowed to do. With Mark, it's far different. This is what he does. So we take 5 minutes worth of information and we give it to Mark. And then Mark asks you if it's correct, and he verifies it, asks you a few more questions. And when he knows what you want to do, which is just about anything you want to do, he'll wrap the body of the trust around what you want. And that's why it works so well. Mark's been an attorney here over 20 years. He's got over 15,000 clients. Over 9,000 of them have trusts, and not one of them has ever been overturned and gone through probate or been successfully contested. And that's really what you're paying for when you get a good attorney like this, is a track record. So this is a piece of paper here. Wait, we might have another question. Let me check.
Okay, it says talk about trustees. Are these usually a lawyer or a family member?
That's a great question too. It's whatever you like. Remember, this is your estate. So you can use a family member. Maybe you want to use one of your beneficiaries or somebody you love, or maybe you want to give everything to your kids, but you'd rather have your sister dole it out for them, or maybe you're not sure who you want to give it out to, or you just want to give it all to charity. You don't have any children. You can get a fiduciary. Now, fiduciary, again, is any company or attorney or anyone you want. Our attorney, Mark Hall, has a couple he would recommend, and I would highly advise you to ask him if you're considering a fiduciary, because we average 80 to 100 trusts every month, and Mark does very well. And there's a ton of fiduciaries that want to work with him, and there's maybe a couple that he will trust. He sorts them out. And so they want to give you the best cost, of course, the best price and the best job, because they want Mark to continue referring them. So it's really a good thing to consider if you want to use a fiduciary, is to ask Mark. But to make sure you understand the answer to that question is you can use anyone you like. Your son, your daughter, your best friend, anyone at all. That's a great question. Thank you. The other one?
Does the signed trust need to be recorded in the county of our residence?
Oh, that's a great question. Okay, so being that my whole life I was raised in California until almost 6 years ago, I'm going to share with you, I've seen a lot of trusts and wills and things on the public record. I personally see, I have to be careful how I answer this because I can't answer legal questions, but if it was up to me, I wouldn't put mine on there, and this is why. Your trust keeps everything private. We fight so hard for our privacy. And when you have a will or no will, when you pass away, everything is now public information, everything you own, everything about it. When you have a trust, everything is private. When you pass away, the trust does not pass away, and therefore nobody gets to know anything. But if you will go ahead and put it on the public record, well, now everybody can see everything you have, everything there is, contact information, everything that you don't want to share is now there. The good news is this. Mark's unusual in the way that he gives 2 original copies. So he's going to give you an original copy. If any of you have an attorney that gave you copies instead of originals, that would make your children or whoever your beneficiaries are beholding to that attorney when you pass away, because they can't do anything without original documents. It guarantees that they're going to call the attorney. And in this case, the attorney charges, what, $300-400 an hour to settle estates or get into probate or whatever they're planning. So it's very important you have the original documents. So our attorney Mark gives you an original trust with all your original documents, and he keeps a second, what he calls a wet signature copy. So he has a second original. So don't worry about losing it or anything, or if the kids can't find it, because on the inside cover, both the front and back cover of our trust, it tells them, please call us. Here's our phone number. This is why we're going to help you settle it. We give you letters addressed. We don't send them out for you. We give them to you, addressed to your successor trustees, telling them their responsibilities, what to expect, asking them to call us with our numbers. So if you wish, you can hand them to that or ask them to call us and let us know we have permission to discuss your estate, because we won't share your estate information with anyone unless you tell us we can. But just so you're comfortable, no, I don't think it's a good idea to keep it private, keep it within the family. And if the documents are lost, we still have copies for you. So you're good. Are we still good to go now?
Does Safeguard or your attorney help people with current tax problems or get past that so they do not have impact on any trust put in force?
Oh, that's a fantastic question. Okay, so remember I mentioned we do the funding. So the funding is where we put, we help you to put all your assets into the trust. So it's very important. The one who does that, it would either be Tom Perzak or John Owen. Those are the owners, and one of them would be assigned to you as your funding manager. Now, they're financial advisors. They are wizards financially, and they have to be, so that they can understand every single account that's out there and know the best way to help you protect it. So if you have any issues like that, please understand they don't want to interfere. If you have, they want to protect it. If you're at risk of anything, they would let you know that some of your accounts are risky and why and so on, because they're protecting you. But they don't want to step on anyone's toes. A lot of you might have financial advisors you've had for 20 or 30 years, and you have great relationships. So they'll help you with anything you ask. The good news is here, if you ask any of those questions, they'll step up and help you. There's no money. They're not going to charge you anything at all. It's included. And the other benefit is if you have a financial advisor, like I said, who's worked with you for a long time, they make commissions. Every time they do something, And even sometimes most of the accounts are sitting around making commissions every year when they don't do something. So if your money earns money or loses money, they still make that commission. So sometimes they'll call you and say, hey, this is a great idea, and they want you to move some of your money or all of your money somewhere, and they benefit, of course. So they're going to tell you why they think it's a good idea. Well, you can call up Tom or John, your funding manager, and ask them, hey, my financial advisor just said this is a good idea. What do you think? Well, remember, Tom and John don't have any skin in the game. They're not making any money, and they're happy to protect you because that's their job. So in the next 2 minutes, they'll tell you in a very easy to understand way exactly what they're offering you and exactly what it means. And then you are in a good position because your financial advisor doesn't even have to know that you've spoken to anyone. You can just go back and say, you know, that's a great idea, or not at this time. And so it's a benefit for you any way you want to handle it. But please ask if you have those questions because they're not going to ask you. All right. So going on, this is a page from Kiplinger. It's a very famous financial firm. It's been around, I want to say, over 120 years. So I grabbed their page out of their magazine. They're talking about the average cost of a trust. And here's how it works. You get an attorney like Mark, for instance. The average cost of a trust, a good attorney, $2,500 to $3,000. That's right. I've seen it less. I've seen it a lot more. Our usual cost is discounted generally. It's in the $2,000 neighborhood, but right now, for everyone who's here putting up with me and listening, you have a great offer here. We're going to give you a no-risk opportunity because I tend to procrastinate and I try to figure out something and they help me. How would you get someone like me to move forward? So we have a no-risk opportunity. Anybody here who's interested in moving forward, I want to let you know it includes attorney's fees and a deed to your home and everything. And our total cost is $995. That's every bit of it. We don't take a single penny at all up front. We just take a little bit of information and we give it to the attorney. We schedule an appointment for you to talk to him. That's either in person or on the phone or one of those Zoom meetings. And he asks you if it's correct and he verifies. And assuming you're happy, you'll give him $430. If you're not, there's no obligation. But if you're happy, you'll give him $430 and your balance of $565. You won't pay that until the trust is in your hands and you're totally satisfied. Now, what that includes is, of course, it includes changing the deed on your main residence or one deed here in Arizona. Any additional properties are $120 each because Arizona has to get paid. So we got to change all the paperwork, of course, and get you a certified copy of your new deed and all of that. Going forward, once your trust already exists, getting property never usually costs you anything. We don't add fees. We just take care of it for you. And moving money around, we're going to help you. We're never going to add fees to that at all. So again, I want to share with you, there's nothing up front to do at all. And the attorney, if you appreciate the attorney, it's $430, your balance $565. If you have out-of-state properties, of course, I'll talk to you. Those are anywhere usually from $100 to $200 each, but I would let them figure it out because it's not our fees, it's just costs involved. So I want to let you know again, it's $995 is your total cost, includes all of this stuff I'm going to tell you. That includes the revocable living trust. Certificates of trust are how we help you with local bank accounts. Your Poor Over Will is a safety net. It lists all of your children in case you have a child you're not getting something to and they came back and said, they forgot about me. Well, no, you didn't. And so the other thing is it'll catch your money. If you move it from a protected account to another bank or an account, we'll go ahead and protect it. But if you don't call us and you pass away, this will catch it and pour it back in. The issue is they have to wait for a day in court and get an attorney, and the judge will say, okay, but it costs time and money. Please call us. It's a free phone call. Your HIPAA, which is your Privacy Act, is included. You have a standalone HIPAA document, and it doesn't say, please consider my powers of attorney like me. It says they have to tell everybody that we're naming by name, so they must tell them. Your financial power of attorney is included. Your healthcare power of attorney is included. Your living will with your healthcare directive is included. If you're on life support and you're terminal, they cannot keep you there like they did to Sherry Shivo. Preparation, recording of all the documents, the deed, everything. Complete funding assistance, ongoing for the rest of your life. Complete settlement assistance. Of course, your successor trustees call us and we walk them right through it. And the emergency medical card for your wallet is a card. If you end up, for any reason, in the hospital and you can't communicate, an ambulance will take you where they're contracted to, so leaving your documents with your doctor doesn't usually help. So if you're out and about They drop everything in admin and they take in the doctor, and admin is just administration, so they're busy. They usually take 10, 20 minutes to glance for medications and so on and glance for someone to call. But they come back 2 or 3 hours later, and that's usually when your spouse or someone important gets a call. And they don't have the ability to help. And if you have that golden hour where a life-threatening situation, 90% of all the life-saving decisions are made in that first hour. It's very important. I would like my wife to be there, or I would want to be there. So this card, they find it in that first 10 or 15 minutes, and it's called an emergency contact card. It has your name and birth date identifying you. It says, in case of medical emergency, please contact the following. There's 3 names and numbers, and those are your powers of attorney, your spouse, your kids, anyone you want. So they get a call right away, and they have the opportunity to get there. But I guarantee you, they're not thinking about paperwork. They're going to leave the phone off the hook and dart out the door. The good news is our name and number is also on that card, and they're going to call us. And we're going to fax over the HIPAA and the power of attorney, so your spouse or your child or whoever it is you've chosen, when they walk in the door, they're already in charge. They're not going to have to try and sit down and do paperwork while they're worried about you. It's tremendous. So you can look us up on Google. We have all these reviews. As you see the first line there, I feel relief now. It's really a wonderful thing. This one happened where they spent the first few minutes with me. I happen to be in that one. Better Business Bureau, again, 5 stars, 30 years and everything. Our next appointment. It takes too long for me to read all these. I'm happy to send them to you. You can just look them up. This one here again on Google, and you see Jeff's name there, Derek, Mark, Julie, Tom, everybody. I can't thank you enough for these reviews. If you appreciate what we've done, I'd hope you'd leave these reviews for us as well. And really wrapping it up, now is not the time to procrastinate. Now is the time to protect yourself. We're going to send you an email, of course, with this form, and it's easy to submit, but I'd like to let you know right down there on the bottom, if you type that into a browser, all you have to do is type it in and hit enter, and it'll bring up this form. And you fill in some basic information, hit submit. This will do 2 things. Number one, it'll allow us to reach out to you and answer any questions, and if you're interested, we'd love to help you. It's also going to give you a dinner on us. We're going to send you a little gift card from thanking you for attending. But if you go ahead and do that right away, we'll be able to reach out quickly and just answer any questions you have, and we can help you quickly. We'd love to hear from you. Also, we're going to follow up with a welcome email and a thank you and give you another opportunity with that typed in. So you would just hit the submit button and fill it out then. But I would ask you, please don't wait. I would love to hear from you. Jeff and I would love to reach out and just answer any questions. If there's any interest, we'd love to earn your business. Again, thank you so much for attending.
Yep, we got some questions.
Oh, great. We got some questions.
Okay, let's go here. What happens to a person's retirement account? Are they part of the trust?
That's a great question. Okay, there's so many different accounts. Again, Tom and John are the experts. I would be speaking out of turn. They're happy to answer those questions anytime you like. It's up to you. There's many accounts that might go in the trust, many that might not, and for various different reasons. And if for some reason they weren't in the trust, then Tom and John would call that company, even they might call them anyways for you and with you standing right in front of them. And they would ask them for the special forms to be sent to you so you can get primary and secondary beneficiaries on those accounts. And sometimes you might put the trust as the beneficiary or so on, or as a secondary. But yes, it's up to you, and they're going to help you understand the proper way to protect each and every account. Thank you. Great question.
I have only one son. He can be beneficiary and trustee?
Yes, he can be beneficiary, he can be the trustee, and he can get everything and do anything you want. Yes, it's any way you'd like set it up. Great question. Thank you. Is there more?
So a copy can be given to our executor, and also we'll have access to the original in our safe to execute the trust when it's time, right?
That's correct. Your executor is your successor trustee in this case, and yes, you can give them a copy if you like. You can give copies to anyone you want. It's your estate. And the original will be there with you, and the attorney, if you need be, he'll have a second original. Great questions. Thank you.
What services are not included in the $9.95?
Okay. That's a good question. I guess everything's there. The only thing that's not there is we don't know what you're going to go do in the future. You'd have to call us and tell us. Well, once you tell us, we can help you with everything. So you get everything. The attorney's included, ongoing funding services. settlement services, the medical card services. If you're at the hospital and you want us to fax over your HIPAA and power of attorney, just give us a call. Tell us their fax number and we'll send it. Everything's included. Great questions. Thank you.
Can we put 2 persons as executors? We have a last will and testament in 1997. We have 3 children. One is mentally handicapped while the other 2 are nurse and high school teachers in Arizona. Can we put 2 people as executors?
Again, great questions. Thank you. So what the trust would do is it would void out it'll void out everything. So the old will be gone. And now you can put anyone you want in charge. So you can put both of them in charge together. You could put a bunch of people in charge. In your case, yes, put them both in charge together. And they're the ones who, of course, would manage the funds for your other child, and it would work out wonderfully. It's a tremendous benefit when you can put somebody you love in charge. Thank you. These are great questions. Absolutely.
Does our property and all assets need to be listed in the trust? And does our property deed currently in our names need to be transferred to the trust?
Okay, so in a nutshell, yes, you should. So in other words, if you don't use the trust to protect the property, then the trust property is vulnerable. So what we would do is we would change title. We'll do it for you. We just need the address. John Kazire is the paralegal that works with the attorney, and he has a virtual title office in his computer. So he'll pull all the paperwork up and do it all for you, and we'll turn it all in and submit it, get it all recorded, and they'll give us a certified copy of your new deed with the trust on title showing you as trustees. And yes, and that way it's protected. So if you pass away, the owners of all your properties will not pass away, and they'll go wherever you want. Thank you. Great questions.
This last one here, please show the slide once again about the products included in the
Okay, so you want to know what's included?
$9.95.
Thank you. Okay, you get all of this here. Where is it? Let me try it here.
Go backwards.
Oh, there we are. Thank you. I was sticking on me. There you are. So you get everything. If you want to do a screenshot there, the revocable living trust is everything we talked about. The certificates of trust, again, helps us. If you have a local bank account, they won't let us change title. So we prepare the paperwork and you just hand it to them. If they give you any grief, you give us a call right there and we solve that problem in a moment. Your pour over will, again, is the safety net, collects the money if you forgot to tell us and moved it to an unprotected account. HIPAA is the Privacy Act, so they have to tell your family what's wrong. The financial and healthcare power of attorney, the living will, we prepare everything, including the deeds for you. You have the complete funding assistance, again, which is simply protecting everything ongoing. We completely help settle your estate, and the emergency medical card I discussed, it's all included. And I can't thank you enough. Let me see here. I think there might be another one here, Jeff. Let's see.
Because my trust is 15 years old, it needs to be updated. That you handle? Yeah, we can handle that.
Of course we can, yes. As a matter of fact, we do it all the time. We would first look at it and help you to understand what it's doing, and maybe you'll help us to understand anything you want to change, and we'd be happy to help you. And it won't cost you $9.95. Those are amendments and stuff. We'd be happy and eager to help you. Please fill out that form. Again, type this at the bottom of your screen here, type this in the browser, fill it out, and we're going to give you a call. http:// that's one word, .com/form. You put that in your browser's address on the top and you hit enter and our form will show up. Just fill in some information, whatever you know, make sure the phone number's in there, of course, and hit submit and we'll give you a call shortly. I want to thank everybody for coming today. Thank you so much. I'm going to leave this up for a few minutes. We'll keep coming back to check for more questions. Otherwise, we're going to go ahead and handle the calls. Thank you again. Thank you.